Welcome to Navigating Complex Divorce and Parenting Issues with attorney Melanie Walls.
Hello, everyone, and welcome back to Navigating Complex Divorce and Parenting Issues with attorney Melanie Walls. Melanie is an OSBA certified specialist in family relations law who regularly helps clients resolve complex financial and parenting disputes outside of court through structured negotiation and mediation. My name's Sean O'Connor, and today Melanie and I are talking about mediation, what makes sense in an Ohio family law case, how the process actually works in practice, and what factors come into play, whether it leads to a lasting resolution, which of course is everybody's goal. Melanie, hi, how are you?
Great. How are you?
I'm doing great. Let's get right into it because we'll always run out of time, I think. When a divorce or custody case begins, how do you determine whether mediation is a good fit for that situation?
You have to look at a couple of things. You have to look at the capacity of the parties. Do they have the ability to communicate and make decisions? Are they going to be open to options, or have they dug their heels in? Because you don't want to go to a mediation, have a party take a position and not be willing to budge or move or consider other options. And the other thing you need to look at is the complexity of the case itself. If you're doing a financial mediation, do they have multiple rental properties? Do they have complex investment accounts? Is there a family-owned business? Do you need to bring in an accountant to assist the parties at mediation? Do you need to bring in, your business valuators to help the parties at mediation? So you need to look at the people involved and the assets and debts that are involved and make a determination as to whether or not this case is a good fit for the mediation process.
Got it. I'm wondering, you mentioned some of those factors that add to complexity, and I'm wondering, are those, or are there other situations where mediation can create complications rather than resolve them?
Well, that happens a lot of times, I think, in the parenting part of a case. If you have a parent with untreated mental health issues or a parent with substance abuse issues, those problems can become more evident at a mediation session, which can really cause the parents to walk out of the room and go their separate ways and stop communicating. One parent may say something hurtful to the other parent that causes them to completely shut down, where you may have started with two parents who were communicating okay. Obviously, this is a tough time for everyone, so you have to keep that in mind. But, sometimes, unfortunately, things don't go well and people walk out, mad, upset, or hurt, and, they stop communication with the other parent, which is unfortunate, but, sometimes it happens.
Right. Yeah, not surprising. I know you're practicing in Ohio, and some of these laws and processes differ from state to state. But, in Ohio, for someone who might be going through mediation for the first time, how does the process typically unfold from beginning to end in broad strokes?
When the parties first come into mediation, they are typically placed in the same room. You go over the mediation rules with them and make sure they have a full understanding of what those are. In Ohio, everything said at mediation is confidential. For example, you cannot later go to court and say, well, Dad said X, Y, and Z at mediation. Mediation is confidential, and you sign a document at mediation agreeing to the confidentiality. Most mediators have their own ground rules for mediation, such as, there isn't going to be any name calling. We're not going to raise voices. We're going to conduct ourselves in a calm, respectful manner. So you just go over the ground rules for mediation. Once they understand that, you typically separate them. and the mediator goes from room to room, and we call that caucusing.
Mm.
Sometimes the parties will agree to stay in the same room, but I find a lot of times they hold back on what they want to say, and you may not get the information you need to help them reach a resolution. So I prefer to separate the parties and go from room to room. And when you're in with a party, you can also say to them, do I have your permission to share this with the other party, or would you like me to keep this confidential? I think that helps the mediator better understand the party's position. I mean, to some people, to an outsider, it may seem like, oh, you're keeping secrets. That doesn't seem transparent. But sometimes when someone is stating their position, it helps to get a little bit more background as to why they're holding that position, and it might help you frame it better for the other party if you understand the backdrop. So,
Yeah.
so that is a reason why I believe caucusing is the better approach to mediation.
Yeah, that's interesting. Both, a window into the process, and also I can, from a strategy point of view, uh, or just an approach. You're building trust. There's power dynamics at play between the people involved typically, and yeah, I can understand how someone might not be as inclined to speak candidly in the presence of the person they're in conflict with. That can be tough to manage, I'm imagining. One concern that I've heard people have is, whether they're expected to reach full agreement. What actually happens if only, some of the issues are resolved?
I still think it's a win. It's a win for the parties. I mean, the court always appreciates when parties narrow the issues. And if you go to mediation and you resolve 70% of the issues, well, guess what? You've limited that for the court. You've saved the court some time. You've saved the parties some litigation costs. Litigating is expensive. You have the attorney time to prepare for trial. You have the attorney time at trial. And I think the more that you can resolve outside of the courtroom, the better it is for everyone. And I can assure you, the courts definitely appreciate that.
I'll bet. Yeah, I hear and speaking to, attorneys in various types of practices where, just the backlog is a big deal, and anything we can do to move cases along is appreciated on all
Absolutely.
fronts. Let's talk a minute about, your practice specifically. Are there, is there a situation where mediation helped move a case forward, even when the parties, initially seem far apart?
You will have parties come to mediation with, a great deal of angst and animosity towards each other. And you really need to try and work around that. You would definitely keep them in separate rooms. The best approach is to start with the least controversial topic and then work your way forward. So you want to start with something you're pretty confident they're going to reach an agreement on, and keep working through the topics that way so that you build up to the most difficult topics. And by then, I think the parties have developed some confidence in the process, some faith in the process, and some hope that they will reach an agreement, because you've given them each a couple of wins, maybe on topics that weren't so controversial, but that they were able to work through with the mediator. So I think that helps them build up their confidence, and then you can tackle the really tough topics.
Got it. Yeah, baby steps, small wins,
And that's exactly
familiarity,
right.
and
You said it
comfort.
right. Baby steps. That's
Yeah.
a perfect
Yeah, that
way
makes a lot of
to.
sense. I mean, we're dealing with, the law is the law, but then there's just people involved, you know? I hear that kind of thing all the time. So communication, let's say it's a scenario, between the two parties, communication is already strained. Um, and you mentioned, an approach, the caucusing and talking to the parties involved individually. Are there other ways that you manage mediation sessions so that, even if there's a lot of conflict, progress can still be made?
Absolutely. Modern technology is great, and that's one of the things that we use Zoom. Although I prefer in-person mediations because I think people are more invested in the process when they're here in person. But Zoom is a great tool that we can use to work with the parties where they're, maybe in the comfort of their home, where they, don't actually have to come to the courthouse or come to a law office, and they can be a little bit more relaxed and they're not so intimidated. And maybe, seeing that spouse across the room or, having to encounter them in a law office or the courthouse really sets up barriers for somebody.
Yeah, can be
You
scary.
can have them on Zoom where they're just looking at that person on a computer screen and it's not so intimidating and they're able to engage in the process.
Oh, that is, yeah, one of the assets for sure of the conferencing now, right? Where just to say nothing of time savings and convenience, just that letting someone stay in their comfort zone a little bit in order to tackle some of these stressful situations is I think, a real boon.
Yeah,
Um,
yeah, that's perfect. You said it.
yeah.
You said it perfectly to allow them to be in their comfort zone.
You mentioned earlier, Melanie, maybe, a marriage with a lot of, complicated financial investments, assets, businesses, properties owned, that sort of thing. And in these more complex cases that have these kind of factors, how does mediation handle those financial layers, assuming, you go forward with mediation in that kind of a complex situation?
So, mediating complex financial cases, you typically want to have your experts either participating at the mediation or available for consult during the mediation. For
On
example,
Zoom.
if you have parties with multiple real estate holdings and each party had an appraisal done and you're arguing about what is this property worth, well, you may want to talk to the appraiser and say, why did you use this comp or why did you use that comp as part of the mediation process. If you're dealing with a family-owned business and each party has retained an expert to value the business, you may want to have them available to talk about, why are we using, the market approach, or, why did you value this part of the business this way, so that you can use all of the tools that you have in the case to try and help the parties reach an agreement. You don't just want to have, a business valuation there, have the parties have questions about it or maybe some confusion and not be able to talk to the person that generated that report. They might be able to give the parties more insight. They might be able to shed some light on some issues that help get the case resolved. They may clear up some gray areas. And, sometimes even our experts might come up with a solution that the parties and the attorneys and the mediator didn't come up with. So
Oh,
in
yeah.
complex cases, you may not want to limit the mediation to just the mediator, attorneys, and parties. Sometimes it's
Hmm.
good to bring in your experts in those particular instances.
Yeah, that kind of a scenario I can see, and I haven't spent a lot of time in court, but I'm thinking that to have that kind of dialogue in real time would wouldn't be something you could easily do in front of a judge in a court. And I tell me if I'm wrong about that, but I'm also, my sense is that mediation is just allows for more flexibility. And so are there kinds of solutions that you've seen come out of mediation that just wouldn't really have been possible in the court in front of a judge?
Absolutely. And I think that's one of the benefits to mediation. And I tell clients all the time, you can agree to things that the court won't necessarily do. What you don't want is you don't want a court, a judge, someone who doesn't know your family deciding your parenting schedule. You don't want a court, setting the time that you're going to spend with your children. You want to be able to, figure that out. And sometimes you have to get creative. I mean, if you have, a client or a parent that works 312s, like a nurse, well, you're not going to have a traditional parenting schedule. You've got to get creative. You have to think outside the box.
Yeah.
Courts are going to look at every court has a parenting schedule. Here's our schedule. It's every other weekend and every Wednesday overnight. And guess what? If you guys can't figure it out, this is what we're going to order. You have firefighters who work on 24, off 48. I mean, do you really want a court deciding your parenting schedule? I mean, that's where mediation really is a great tool for parents to use to come up with what isn't a traditional parenting schedule and isn't necessarily something a court would ever order. That's where you get to be creative and think outside the box.
Yeah, great example. Great. I mean, you're going to get a one-size-fits-all solution out of the court potentially. They're pressed for time. They're not there to be creative. Whereas in mediation, you can really talk through the different factors. I love that. With just a couple minutes we have left here, Melanie, I like to get a little more, I don't know, say on the practical side, but someone's listening right now and they're trying to decide between mediation and litigation. What should they be thinking about in terms of cost, control, and long-term outcomes?
I think that mediation should always be an option on the table for parties.
Okay.
Litigation is expensive. Mediation, you can have multiple sessions to try and work through your issues. Court, it's a one-shot deal. Here's your trial date. You get to put on your evidence. The other side gets to put on their evidence, and the court makes a decision that you may or may not like. Mediation, you can have, multiple bites of the apple. You can go for a session. You might be making progress, and you can schedule another session. Mediation also gives you the opportunity to think outside the box and get creative. I mean, you can put all the creative solutions you want in front of a judge, but you have no control over which option the judge might pick, if any of them. In mediation, you're in control of the outcome. In court, you're not.
Now, wow. I mean, I love that because I can see too, harking back to, the power dynamics and, control issues and whether you're comfortable in some of these settings, this idea that both parties end up with some control over the process, which has got to be just good for the overall tone, if you will, and reducing some of the uncertainty and the fear, because no matter what, these are emotional and often fraught conversations. So good stuff. We are out of time, but I know we'll talk again, Melanie. Thanks for sharing your expertise and insights, and I look forward to a future conversation.
Thanks.
That's it for today's episode of Navigating Complex Divorce and Parenting Issues with attorney Melanie Walls. If you'd like to learn more about Melanie's work or schedule a consultation with her, visit the website melaniewallslaw.com. I'm Sean O'Connor. Thanks, as always, for listening. Don't forget to leave a thumbs up, subscribe to the podcast, or share a link with this episode with someone who you think might benefit from the conversation. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.